Ready when you are.
I have 5 minutes for rebuttal. May it please the Court, my name is Richard Escobar, and I represent my client, the appellant here, James Roy Love. The facts of this case, I think, are not in dispute. The facts are pretty clear. Law enforcement arrested Mr. Love while in the process of my client, Mr. Love, attempting to manufacture methamphetamine. The seizure of evidence in this case consisted of the products of manufacturing. Those products were toxic chemical solutions, coffee filters, nylon stockings, Pyrex dish, etc. The evidence that was supporting my motion was quite compelling. It was evidence from 2 DEA chemists who testified that the majority of the evidence that was seized, that being those products of manufacturing, contained very, very small traces of the narcotic D-methamphetamine. In fact, those particular experts testified that if the distilling process had run its course and not been interrupted, at best, Mr. Love would have realized no more than approximately 6 grams of methamphetamine, far below even the lower standard of trafficking in 893.135. There are various stages of trafficking within that statute.
So how is this different from all those cases where you have a small amount of cocaine that's cut and spread out in kilos and kilos, and we get them on a trafficking amount on that?
Because our statute, our trafficking statute, like the federal trafficking statute and the federal sentencing guidelines, are based upon the marketing theory. And that marketing theory punishes individuals that possess, manufacture, and distribute a greater amount of usable narcotics. The problem that we have with this methamphetamine that was seized by law enforcement, it was not usable. It was not able to be consumed because it was toxic. And so that doesn't support the market theory. But the individual that has a kilo of cocaine and wants to make that kilo into 5 kilos and has 4 kilos of cut and mixes it together is now going to distribute a greater amount of cocaine to the public. And therefore it supports the basis of the statute, which is deterrent of public harm pursuant to this market theory.
Well, Mr. Escobar, you're talking about the marketing theory behind this criminal statute. That's an interesting argument. The problem is this is really a question of statutory construction, your first issue. This statute could not be any clearer. It penalizes based on mixtures, and mixture is defined, and it includes any other substance that's mixed with any listed drug.
I'm glad you pointed that out, because I'd like to cite for the Court a couple of cases, Supreme Court of Florida cases, dealing with this issue of statutory construction. And one is called Vildabill versus Johnson, which is located at 492 Southern 2nd, 1047. It is a Supreme Court of Florida 1986 opinion. And I'd like to just read a little excerpt from it because I think it's very important. It says, the legislative intent must be given effect, even though it may contradict the strict letter of the statute. And it's citing another Supreme Court of Florida case.
Mr. Escobar, is that case cited in your brief?
It wasn't, Your Honor, because it's based...
You can't argue it then.
In the reason that I'm arguing this...
You can't do it, Mr. Escobar. It's not fair to your opponent.
Your Honor, I argued statutory construction in my brief. I didn't argue...
You cannot argue cases. You cannot rely on cases that are not cited in your brief.
Your Honor, I believe that there are... This particular position of statutory construction is very basic in the law, and that is that the general intent, the specific intent of criminal statutes are the most important to be enforced. And unfortunately, statutes can't be written to encompass every scenario. And therefore, many times, even though the plain language of the statute may appear to provide one result, if that particular result is inconsistent...
Let me ask you a question about the language of the statute. They're talking about trafficking, but then they define trafficking. They're talking about any person who sells and so forth, manufactures.
That is not the only, 893.135 is not the only statute that deals with the term manufacturing. If you look at 893.13, which is the general possession and delivery statutes as well, they also deal with the term manufacturing. 893.135 deals, the punishment in that section deals with the weight of the narcotic. And so the focus of that statute, the intent of that statute is to punish according to weight. In fact, if you look at the statute, there are various degrees of punishment based upon the weight. So you're not punishing in 893.135 manufacturing. What you're punishing is the amount of weight that is distributed either pursuant to delivery, possession, manufacturing, etc.
But he's convicted under a statute that's talking about manufacturing.
He is convicted, absolutely, and 893.13 also talks about manufacturing, but he is convicted and punished based upon weight, and that weight has to be consumable weight. It can't be just weight that is a toxic byproduct of the manufacturing process.
The problem with that argument is the statute just won't support it. The clear language of the statute won't support it. 893.135.1F1 talks about a mixture.
And you're on.
Let me finish.
Okay.
893.135.6 says that the weight of the controlled substance is the total weight of the mixture, including the controlled substance and any other substance in the mixture.
Your Honor, that similar language was contained in the case of United States of America versus Jennings, which is argued in my brief, which is a 1991 Sixth Circuit case, which is also cited by the 11th Circuit as controlling in our federal jurisdiction. That federal statute is identical to our state statute in reference to that mixture in manufacturing. It's no different. In fact, if you look at one of the footnotes in that particular opinion, you will see that they outline what that statute embodies in the form of language. So all of the cases that I have cited, especially United States versus Jennings, because it deals with meth. In the Jennings case, there was a crock pot.
I thought the federal cases had to do with the sentencing guidelines.
No. The United States versus Jennings also referred to the federal statute in its opinion and outlined the language of the federal statute in dealing with this crock pot case.
Are you
I can get you
saying
the page.
it's identical to these statutories?
Identical in language, meaning that in that federal statute, it did talk about the mixture in a manufacturing process. And in fact,
does it say that mixture, that you weigh the whole mixture,
oh yes,
including the non-listed, non-drug aspect?
a plain reading of the federal statute in Jennings, yes.
What is the statute? 18 U.S.C. what?
I think it's 841, Your Honor. If I can pull
Sure,
it,
please.
I can bring it to you real quickly. I believe it's 841, if I'm not mistaken. It looks like it's 21 U.S.C. 841B1A 8.
21 U.S.C.? That's not part of the criminal code.
21 U.S.C. 841B1A provides that.
Sentencing code.
That's the sentencing guidelines.
That is for the sentencing guidelines, but they go further in this opinion and talk about the actual statute that also has the word manufacturing. And in the sentencing guidelines, it does say manufacturing as well. Both the federal statute and the sentencing guidelines both encompass the word manufacturing. And so in 893.135, we are not punishing the manufacturing, which is what I believe the appellee wants you to focus on. We are punishing weight. And because in this particular case, in particular, a very minute amount of the drug, if it was distilled through its course, was only going to be 6 grams of methamphetamine, it would not be a trafficking amount. it is clear that the liquids that were tested by DEA chemists were toxic and not to be ingested in any way, shape, or form. In addition to Jennings, there is another federal case from the 11th Circuit that I believe, yes, it is a guidelines case, but the language, again, is very, very similar. And again, all of these cases are talking about the application of this market theory, which I believe even this court in the Hudson case alluded to, but never decided the issue because it was not preserved. All of these cases has at its foundation this market theory, and if in fact it doesn't support this market theory, then that injustice is cured. The language of these federal cases that I've cited for Your Honor is very, very strong.
Mr. Escobar, again, I hate to interrupt, but you asked to reserve 5 minutes.
Yes, Your Honor.
4 minutes and 20 seconds.
Your Honor, I will come back for rebuttal.
May it please the Court, Ian Cotner, on behalf of the State, the appellee. The statute in question is absolutely rationally based. It is perfectly reasonable that the legislature, in enacting this statute, sought to ensure that a legitimate government interest, that is the public health, safety, and welfare, was protected. They did so not only by making illegal...
Your opponent never got to that argument.
Yes, sir.
You want to focus on that one instead of the one he did argue?
No, sir. No, sir, I don't actually. What actually this court was, all three of you were on the right track when you spoke to not the marketability, but the plain meaning of the statute. The plain meaning is absolutely very clear. The statute itself includes any mixture containing amphetamine or methamphetamine. It goes through the specific, the enumerated chemicals included in that statute, and it includes equipment.
This clarifying provision that the legislature put in 2003, that was in fact intended to overrule a Florida Supreme Court decision that had reached the opposite conclusion, wasn't it?
Yes, sir, that's correct.
So if there were any doubt, it'd be pretty clear what the legislature had in mind, wouldn't it?
Yes, sir, that's exactly correct.
Well, wasn't the Florida Supreme Court decision that you had to look at the content of the drug, the proscribed drug within the entire substance that was being distributed? I mean, he's right, isn't he, that if you look at this from they manufacture for distribution one thing, and now they're being punished for a byproduct of the manufacturing process that's essentially a liquid that is not unlawful, except that it contains a minute amount of the proscribed drug, the methamphetamine, simply because they were unable to extract that for sale.
Your Honor, I think the statute focuses on two things, and that is that the actual distribution of the product, the final sellable, marketable product, as appellant would have you believe, but as well as that is twofold. It's also, focused on the manufacturing process itself and the danger that poses to the public.
Yeah, I think that has to be your position, that the statute says no manufacturing, any manufacturing will be punished as severely as distributing the drug in these quantities.
Based on the quantity, yes, sir. Yes, sir.
And that is, after all, what the statute is talking about, manufacturing, and then, as Judge Webster has pointed out, mixture is defined by statute to include...
Exactly, and
of course, this is not, let's see what it says. A solution containing a controlled substance is a mixture.
Actually, the mixture is defined, I believe that is actually the definition. In fact, one thing I did want to point out is that the U.S. Code, contrary to Florida statute, doesn't actually define mixture, whereas the Florida statute.
That's only in the sentencing guidelines. Is there a definition in the guidelines?
It's in 841 in this, I believe that's sentencing guidelines, yes, sir. And it is not, I want to repeat, it is not defined in the U.S. Code. It's defined in the Florida statute.
I say it's not defined even in the sentencing guidelines.
To my knowledge, no, sir. The fact of the matter is, Your Honors, that this is just it's a plain meaning case. You can look at the statute. You can determine exactly what is to be included. It's the methamphetamine itself. It's any mixture. It's the equipment utilized, or it's any mixture found in conjunction with that equipment utilized in the manufacturing of
Well, isn't that going to
methamphetamine.
essentially make every methamphetamine case a trafficking case if it's charged that way?
It could potentially.
Because of the amount of liquid you need to make the final product.
It could potentially, unless it's actually the finished product. Yes, sir.
And of course, the question then becomes, who has the right to decide whether that's what the law is going to be?
And
In our system, it's the legislative branch.
that is correct, sir.
And then we get to the constitutionality of it, which is what you wanted to argue first. Okay.
Let me, before you leave the question of statutory construction, is there any other statutory provision that purports to outlaw the manufacture of any quantity whatsoever?
Yes, sir. In fact, I believe it was Section 893.149 Florida statutes makes it a second-degree felony, even to possess with the intent to manufacture, and then any of the chemicals listed as precursors in another statute, which is 893.033. So, in addition to those two statutes, there's another statute that makes it a first-degree felony just to have a child under the age of 16 present during the manufacturing process. That's 893.13G.
All right, but my question is there a statute that says manufacturing methamphetamine is against the law?
Well, that would be the statute that we're looking at here.
And this is the only place in the criminal code that proscribes that conduct?
Other than the statutes that I just mentioned, yes, sir. The one with 893.149 does make it a secondary felony to possess the chemicals that are used to make methamphetamine with the intent to manufacture methamphetamine. So yes, sir, those. But it is generally everyone's prosecuted under the trafficking statute. Yes, sir. The methamphetamine manufacturers are prosecuted under the trafficking statute if it's 14 grams or more.
All right, thank you.
All right. Would you like me to go into the other? I believe that the only argument in my mind is the plain meaning. Well, there are other arguments that appellant would raise, but I believe that the plain meaning of the statute is clear, and unless you all have any questions, I would just ask that the court affirm the judgment and sentence.
Well, they are arguing that if that is the proper construction of the statute, it is unconstitutional. What do you say to that?
That it's, I believe what you're getting at is the due process claim that they're making. Well, they're actually making a couple constitutional claims, which is equal protection. To the equal protection claim, you know, I think it's pretty clear we don't have a suspect class here, and we're not dealing with people that are similarly situated. Methamphetamine manufacturers are not the same as methamphetamine distributors, as appellant appears to be making that argument. In terms of it being the due process claim, this law is absolutely reasonably related to a legitimate government interest. It's reasonably related to the interest of protecting the public health, safety, and welfare from the dangers inherent in the manufacturing process itself. The dangers are twofold: one, in the distribution, and two, in the manufacturing process itself. And that's what the legislature has tried to do here. They've seen that.
It's very volatile, isn't it?
Yes, sir, it is.
It can blow up very easily.
It can. It can blow up, start fires. The fumes themselves can kill a person. And in fact, we're lucky in this particular case that the 6-year-old that was in the house wasn't harmed. He was taken to the hospital, but he wasn't harmed. Beyond that, and as far as the cruel and unusual punishment claim that appellant is making, we don't think that this punishment is grossly disproportional to the crime. So does that address for you the constitutional claims? I mean, it does. To me, it's a plain meaning. It's a plain meaning case, and it seems fairly straightforward. But if you all would like me to go into any of this further, I'd be happy to do that. All right. With that, we ask that you affirm the judgment and sentence below.
Mr. Escobar?
May it please the court again. I respectfully disagree with opposing counsel. The Florida statutes deal with the issue of just manufacturing without reference to weight in other statutes. Here, in this particular statute, the statute that my client was charged with, 893.135, deals with the actual weight and increases the penalty based upon increased weight. Therefore, if we're focusing
Or is he right that the only other statute is the one that proscribes possession of the ingredients necessary to manufacture?
Your Honor, I believe that 893.13 also discusses manufacturing, but I would have to actually go back to that particular statute and review it. But I believe that that statute also has the words manufacturing within it. The specifics of 893.135, however, deal strictly with weight. It goes in stages in severity, from a 3-year minimum mandatory to a 7-year minimum mandatory to a 15-year minimum mandatory.
Mr. Escobar, the question I asked counsel for the state was, isn't every methamphetamine case going to be a trafficking case based on weight? I mean, don't you...
Manufacturing?
I mean, every manufacturing case going to be over 14 grams based on total weight?
That would be the absurdity if we interpret it in as some of...
That's what the legislature wanted to do.
Your Honor, but many of the cases that have interpreted the statute in that fashion, just plain language, have ruled that it would be absurd for us to interpret that language in that manner, because it really gives no meaning, no intent to what the legislature intended. The legislature here intended for that...
If the legislature intended, there shall be no manufacturer.
Maybe in another statute, but here what the legislature said is that there should be no manufacturer...
But if there is no other statute saying that in terms, you don't have the redundancy you are assuming in your argument.
There is no doubt that there are other statutes, including 893.14, that specifically deal with the manufacturing process. But here we're dealing with the quantity that's being distributed for consummation by the public. And that's what the legislature in this particular statute is trying to prevent and trying to punish. The more you're able to distribute, the more the punishment. Here, because this individual had absolutely no ability, after the distilling process would have been done, to distribute a trafficking amount, he doesn't fit in within 893.135.
You're saying if the police had arrived, I don't know, an hour later, or he would have discarded the byproducts?
No, what I'm saying is that if the police would have come an hour later and he would have been finished with the process, the best that he would have realized from all those chemicals and all that distilling process would have been 6 grams, which would not have been a trafficking amount.
Except that it talks about the weight of the total mixture.
As does many of the other statutes that,
Which ones?
well, certainly the sentencing guideline statutes have interpreted very similar language, and
The federal sentencing guidelines.
Yes.
That's not
And
binding.
there are federal circuits that rule your way, and there are federal circuits that rule the other way.
I think it's
So-
about 6 my way, 2 their way, and the Florida 11th Circuit rules in my
Okay, so
in my
6
favor.
is more than 3, so
No,
we should go with that.
no, but I think that the federal, the 11th Circuit did a very thorough analysis in the case of United States versus Rolande
Well,
Gabriel.
my point is, I read all these cases, and everybody did a very thorough analysis. It's a debatable proposition.
And I understand that there are 2 arguments to be made in this fashion. However, going on my second issue on appeal, the courts have taken the position, using the rule of lenity, including Rondell Gabriel, that the rule of lenity should be applied to prevent an absurd and glaring unjust result. And don't we have that here? We have an individual that at best, when that whole process was going to be completed, was going to realize 6 grams of methamphetamine, where someone else, some other individual, that would have had 200 grams of methamphetamine would be punished alike. That's an absurd result.
Let's suppose, for purposes of argument, that the legislature of the state of Florida concludes we want to stop people from trying to manufacture methamphetamine. That is so dangerous, we want to stop them from doing that. Isn't that a rational purpose?
It is, and if they want to do that, if that was their intent, then just say that and forget the weight. We don't have to worry about weight then. Eliminate all these categories of weight. You want to punish manufacturing, punish it, and give them a 10-year minimum mandatory, a 20-year minimum mandatory, but forget about weight. The problem here is that the legislative intent is clear. They were focusing here on the market theory with weight. And because of the fact that this individual could have only realized at best 6 grams, he doesn't fit within the trafficking statute. He fits within some other statute dealing with manufacturing, but not within the trafficking statute. And I think that certainly the statutory construction rules that we all know allow us to look at other jurisdictions interpreting similar language and coming up with a just result. So we're asking the court to reverse the court's denial by motion to dismiss in this matter.
Thank you, Mr.